Hi, you're listening to the Lawyer Society legal podcast for lawyers, practicing advocates, law students, and judicial exam aspirants.
In this episode, we'll be talking about whether a magistrate can direct police investigation in a 138 check bounce case. This answer can be very simple and it is a very brief one. There's a very brief answer to this question. For that, we need to read Section 142 of the Negotiable Instruments Act. Section 142 is about the cognizance of offences committed under Section 138 of the NI Act, which is check bounce offences. Section 142 reads, notwithstanding anything contained in the Code of Criminal Procedure 1973, no court shall take cognizance of any offence punishable under Section 138 except upon a complaint in writing made by a payee or, as the case may be, the holder in due course of the check. So a bare reading of this section makes it evident that no court can be taking cognizance of a check bounce offence except upon a complaint made in writing by the payee or the holder in due course. This makes it evident that a police report cannot be submitted. That is, the police cannot investigate a check bounce case after registering FIR and finally forward a police report under Section 173 Clause 2 to the magistrate. This part is solved. If you require any case laws to support this, in case your opposite party has given a police complaint and the police mistakenly has registered 138 case against your client, then you must be referring to these two cases from the Karnataka High Court. One is H. Mohan versus State of Karnataka. This is from the year 1990. And the other is R. Mukundaiah versus State of Karnataka. This is from the year 1991. I will leave the citations in the description box below. Now, subsequently, the second question is whether post-cognizance the magistrate can direct an investigation under Section 202 of the Cr.P.C. As you know, Section 202 or an investigation under Section 202 is not the same as one that happens after filing of FIR. So, an investigation under Section 202 is not specifically barred by Section 142 of the NI Act, which is only speaking about the cognizance stage. So, after cognizance, it is obvious that the magistrate can, before issuing summons, if he needs, in certain cases, it is also mandatory if the accused person is residing outside the territorial jurisdiction of the magistrate, and also in other cases where the magistrate wants to use his discretion, he may hold the matter and direct the police to conduct an investigation under Section 202, after which he will peruse the material and decide on whether he should be dismissing the complaint or be taking the matter further by issuing summons to the accused. So this is not barred by the NI Act, and only the investigation which will end in a police report is barred by the NI Act. I hope you found this information useful. This is very brief and a very short podcast episode. I'll be coming up with something more interesting in the next one. Do follow us on the Spotify app and also click on the bell icon to receive regular notifications. Do consider subscribing to my digital law magazine, the details of which I will leave below in the description box. Thank you.